Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. And you said, Judge West said I better not do this again, and you did it again. It just makes me look like an idiot. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person. All right, Victavia Sanders. All right, ma'am, you're Victavia Sanders.
Yes, ma'am.
And Ms. Sanders was previously here in cause number 22-39884. Entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up. And that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then
Okay, let's go through that.
the necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
I'm coming from the pocket side. 244 on the mirror.
On patrol 115-826 cars.
Hey, stop. You're being detained. Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so I thought she was detained right now.
She just took everything out and dumped it on the floor back there.
We're gonna
Put your hands behind your back. Wait for her.
Once already.
and just stay here.
Do you have any other merchandise on your person?
Anything illegal underneath you?
They can take this. I gotta walk out the store. Yeah, we did. I watched you on the camera. What? I watched you on the entire time.
Okay. What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, stand it on the counter.
Can you text this out from the phone?
Not at the moment, no, because
I'm talking about.
Where you're acting like a fool.
Oh, no, I'm not about to
Just like I said, just put it all right here.
I don't have
Nothing else in your
no,
notes or anything?
no.
What matters here is not who's in the courtroom, it's what the evidence shows. The officer involved is unavailable to testify, but that doesn't weaken the case. Body-worn camera footage is admissible evidence, and in hearings like this, it often speaks louder than live testimony. This isn't a trial on a new charge. It's a probation revocation hearing. The legal standard is lower, and the court is allowed to rely on reliable evidence, including video, to determine whether a new offense occurred. What the footage captures is the basis for that finding. The defendant detained, merchandise recovered, and conduct consistent with another theft while already on felony supervision. The court isn't weighing intent here. It's assessing whether the conditions of probation were violated. And from a legal standpoint, the video provides a clear answer.
All right, any other evidence with regard to count 1?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage, now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's actually.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The
What-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
So do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids, besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard, because they been with my mama, and my mama had dementia, and she.
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm
that
not.
if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot. for giving you the opportunity in the first place. At some point, you have to stop. Some point you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right? So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way.
What stands out in this sentencing isn't just the revocation, it's the judge's clarity about responsibility. The court makes something unmistakably clear. This outcome wasn't imposed by the system. It was created by repeated choices. The judge explicitly rejects the idea that incarceration is somehow the court's doing. Probation was granted, boundaries were set, and the warning was direct. What followed was a conscious decision to cross that line again. This case also highlights a pattern courts see far too often. When sentencing becomes unavoidable, defendants suddenly invoke family, children, parents, caregivers as mitigation. But the judge draws a hard distinction here. Concern for family can't surface only when consequences arrive. If those obligations truly guided decision-making, the behavior that triggered revocation wouldn't repeat itself. From a legal standpoint, the court relied on objective evidence, body camera footage, admissions captured on video, and prior history, not speculation or emotion. The judge wasn't weighing sympathy against punishment. She was enforcing the integrity of probation itself. Once probation becomes optional, it loses all meaning. In the end, this ruling isn't about being harsh. It's about drawing a necessary boundary. Second chances only work when they're taken seriously.